Call the third case on this morning's docket. That is case number 102883, State of Kansas v. Jonathan David McCune.
May it please the Court, Michael Barty appears on behalf of Mr. McCune. I would like to reserve 3 minutes for rebuttal, if I may.
3 minutes is granted.
In this case, since the filing of our brief, and I believe the state's brief, issue number 5 raised in our brief has been decided against our position by this court. So I will simply stand on the brief on that issue. That concerns the constitutionality of the lifetime sentence and the lifetime post-release provisions. And I will also stand on my brief on issue number 6, which concerns the Apprendi issue with the requirement that the state prove criminal history beyond a reasonable doubt. The first issue I raise is the 6455 evidence in the case. This concerns a rather long history of events between the alleged victim in the case, the defendant, and the alleged victim's mother. There was a hearing before the district court on the admissibility of that evidence. The court did decide to admit the evidence and seems to have jumped to the element of credibility as the driving point in admitting this history of violent offense and sexual offenses that had occurred over months in various locations.
Mr. Barty, I want to interrupt you because I'm interested in why there was no discussion of the amended 6455, which was in effect, as the state points out in its brief, barely, but it was in effect at the time of this trial. Not at the time of the pretrial, but it was
Right.
by the time of trial. And you don't mention it in your brief, that, as I recall, and I'm just wondering how are we to deal with that, because that changed the landscape, obviously, of what's admissible.
It did.
And what should have been perhaps admissible, and for what reason at that time.
It was not discussed at all in the district court, so there's no real analysis by the district court of that new language in the statute. And I know that we may be stuck with a district court made the right decision for the wrong reasons because the law had changed and nobody had addressed it. But I think the issue should be evaluated as the district court did so under the then existing provisions. That's what the focus of the appeal is.
Why should that? Why? Why would we not apply the law that was in effect at the time of the trial?
Because we've appealed the decision of the district court that was made, in essence, before that change in the law when it ruled on those issues at the pretrial conference.
But we often say, just as you've pointed out, that a district court can be wrong for the wrong,
right
for the wrong reasons.
Right.
And why would that principle not apply?
And I think it's procedurally for the reason that the issue was litigated. The parties relied on the law as it existed then.
But that was wrong.
And, well,
The law as it existed then is not what the court applied.
I understand that.
Let me go at it a little differently. Even though it wasn't litigated, do you think we have enough in the record that we could determine whether the prior sexual abuse would fit within the new statute as being relevant and probative to the charges here?
Well, we've got the issue of the court's requirement to find that it is relevant to prove a material fact in the case. And then the other thing we've got is a lot of violent evidence that doesn't appear to have been affected by the amendment.
There are really three categories of 455, aren't there? Or maybe even four. I mean, there's prior sexual abuse of the victim. That's one category. prior physical abuse of the victim unrelated to sexual abuse. There's violence toward other members of the family, right? And then we have the convictions issue. There are really 4 categories that we need to analyze, isn't that right?
Yes.
Okay.
The convictions, evidence of the convictions didn't come in the trial, but your allegation is that they were used as a threat that impeded your ability to confront the witnesses?
Yes, and that's really issue number 2 that we raised. The court kind of put a rope around defense counsel in the defense of the case and said, all right, we're introducing the evidence of these other incidents to show essentially the credibility of the accusations that AR is making. Now, we have a guilty plea. If you attack the credibility of those accusations in the jurisdiction that resulted in that guilty plea, I will allow evidence of that guilty plea to be introduced. So the court admitted the 455 to bolster the credibility, in essence, of the alleged victim, but then told the defense, you can't attack that credibility. You can't raise the arguments that I used to justify the 455 evidence in the first place. You can't attack the credibility of that alleged victim for inconsistent statements or for not reporting, delay in reporting the incident even when talking to other police. If you attack her credibility as far as that Warrensburg, Missouri case goes, then at that point, that guilty plea is going to come in. What that did was deny the defense the constitutional right, essentially to cross-examine the witness and to present their defense in the case.
But under the new statute, there's not much question that that conviction would have been admissible, is there? It was a prior sex offense, which would be relevant and probative, at least the propensity, in this case, wouldn't it?
Well, at what point do you stop piling on that evidence? Because we've got evidence.
That's not.
Well,
If it were, where I'm going is, if it would have been admissible, then the threat to admit it, I don't see how that violated your right of confrontation. You just caught a break that the court didn't admit it in the first place. Do you understand what I'm asking you?
well, I do, but the court was telling the defense, you've got to forego cross-examination on this incident to keep that out.
Well, and then that was the defense choice to do so. It didn't prohibit. It made it a strategic decision on the defense part, but it didn't prohibit your attacking credibility.
It didn't prohibit it. I think as a practical matter, it prohibited it in the sense that we're going to allow evidence that I've determined is too prejudicial. And I think that was really the court's decision for not admitting the plea itself. If you defend yourself by attacking the credibility, at that point, you will trigger this guilty plea that you entered.
Can you back up on that? I see a more basic issue, I guess, with your argument about the confrontation issue. Even assuming you have a confrontation issue or that you were denied your right to confront the witnesses, you're talking about what he's giving up is the statutory right to not have his convictions admitted. So you're balancing or the quid pro quo is essentially statutory, and the statute or the case law, that you cite has to do with the, two constitutional rights, the Fourth and Fifth Amendment, giving one up to save the other, and you don't have that here.
Well, we've got the Sixth Amendment confrontation cross-examination right that he's being forced to give up.
What's the quid
protect
pro
the-
quo? What is
The-
it?
the-
It's a
the qu-
statutory.
The quid pro quo is that you're not going to engage in a full cross-examination of AR in exchange for us or me valuing this statutory right that you have
That's what I'm
under
saying, but the case law
455.
that you cite has to do with two constitutional rights that you're having to choose between. That's the whole idea of it.
I understand that. And much of 6455 is really grounded in the right to have a fair trial, to have a fair jury fairly evaluate the evidence. It's the purpose of the statute is to protect the due process right to a fair trial. Although it is obviously a state statute, but defendants have the right, the due process right to a fair trial. This impacted also when part of an incriminating statement of Mr. McCune's was admitted. This was a question-answer session with a detective in which only part of the conversation, only part of the statement was admitted. And that was the part where Mr. McCune said something to the effect of, is she accusing me of raping her without a condom? The state then stopped, and the defense, and this is where we reach that, the rope or the chalk line that says don't cross this line. The defense wants to question the detective to establish why that statement was made, what the context was, and the exculpatory nature of the conversation that followed that immediately, which was that I've had this disease for years. I'll bet she's been tested and negative. I have it. That is, the defense argues, that's exculpatory evidence that it was prohibited from using unless it wanted to face the jury hearing about the confession or the guilty plea that Mr. McCune had made in another jurisdiction. It wasn't, and this isn't really rebuttal. You know, sometimes a defendant can open the door maybe to a confession, but that's generally done with affirmative evidence, with testimony. Pointing out delay in a report, pointing out facts that may undermine the credibility of a witness are different from actually introducing some evidence that would be contradicted by the confession. You know, if Mr. McCune had testified here and denied everything, at that point, you know, the confession may be admissible as rebuttal to that. But the confession was being used here really to prevent defense counsel from defending her client by simply asking credibility-based questions that arose from that incident. The third issue we raise in the brief concerns...
Counsel, before you get into that, you're out of time. Would you like about 30 seconds to wrap up?
Yes, thank you. The third issue is concerning the psychological evaluation that was requested. The fourth issue is the vague nature of the sentencing structure in this case, and I will simply stand on my brief on those two issues.
Do we have any more questions? All right, thank you, counsel.
May it please the court, the state appears by Stephen Obermeyer. I filed a 609 letter a couple of weeks ago addressing issue 3, the psychological examination. So I would just rest on the brief and on the 609 letter on that issue. With regard to the first issue, we did have a new statute. The new version of 6455 had been in effect for about a month by the time of the motions hearing in this case. The trial court, Judge Bennett did not have the benefit of State versus Prine or State versus Spear, so you know, I know attorneys are, maybe trial judges are hesitant to interpret a statute too much until the appellate courts tell us what it says.
Well, it's worse than that. I mean, there doesn't seem to be any recognition that there was a new statute. At least I didn't see any in the record. By any of the attorneys, by the judge. I mean, I don't think it was a situation where he was waiting for us to interpret it. There was no attempt to apply it.
That may be correct. And the one difference, I guess, is that most statutes go into effect on July 1 of that year. And this one went into effect upon publication in the Kansas Register. And I don't know if they knew that or even thought. But so what Judge Bennett did was he went through, he'd had many cases before Gunby and after Gunby and went through that 6455 type of analysis and admitted a lot of that to show the relationship of the parties, why the victim delayed in reporting, but excluded the part about the conviction. And so he did go through a weighing of evidence. But I agree. I think that in hindsight, under Speer and Prine, maybe even the conviction evidence would have come in. All that evidence would have come in.
Well, now, is that true that the court found that the prejudicial impact of that conviction outweighed its probative value?
Well, he excluded that, so I think that was, I think so. I know he went through a probative prejudicial analysis and that it's in volume 3.
But even under the new statute, I mean, if the court made that ruling, then I don't know that we can say right for the wrong reason with the new statute, can we?
As to the conviction evidence, yes, that's probably true. But as to the
But wasn't his ruling that he would allow it if the defendant began to attack the credibility of the victim? At least impliedly, a statement that if credibility is on the table, then I believe the probative value does outweigh the prejudicial value.
yes,
And so can't we assume that if we were to apply the new statute?
I think you could assume that, and that's what brings us to the issue 2 issue, the fact that there was some abuse in Warsaw, Missouri, for which the defendant had not faced charges. He'd been brought to Warrensburg, Missouri, and pled guilty to 2 counts. I think a sex-related offense and something related to the cigarette burning, and got a 13-year sentence. And the judge, I think the attorneys basically knew that the Warsaw evidence was wide open as far as cross-examination of the victim and victim's mom based upon that. But if they went into Warrensburg and started to challenge victim's credibility as to what happened there, then we have the defendant's plea to that, to corroborate her testimony. So I think that there is not a quid pro quo. It's just we'd rather not have this evidence come in, so we don't want to go there. And I'm not sure what evidence they would have gone into as far as Warrensburg that would have made a difference in that. And defense counsel handled the issue pretty well in closing, just saying all this other Missouri stuff just kind of shows the relation of the parties. You need to consider what happened in Lenexa on these 2 dates, and argued why that wasn't the case.
Going back, Mr. Obermeyer,
Yes.
you made the statement that Prine 2 would indicate that all that evidence would come in or should have come in. That's not exactly correct, at least under Section D of the new statute. It doesn't allow propensity evidence for all prior bad acts. It talks about certain acts. So all of the evidence would not have come in here. Am I evaluating that correctly? I mean, even under the new statute?
I think under as Prine interprets the new statute, as long as the evidence of another act or offense of sexual misconduct.
It has to be sexual, is her point. You also have
Okay.
prior bad acts of physical.
Okay,
Mis-
I see what you're saying.
4 categories
It
again.
it would come in as to the sexual
at least as to that, under
Right.
section D, and it would come in, basically, could come in for propensity.
Right. So, the trial courts, I mean, the trial court ruled that the physical would have come in to show the relationship of the parties, to show an ongoing course of conduct, to explain the alleged victim's reasons for delay in disclosing her allegations. And the jury was instructed as to those factors under what was the Gunby directive, that this evidence, if you go into this evidence, the best thing to do is instruct on it, and that's what was done. And I still think that physical evidence would still have come in to explain the relationship of the parties and the motives for their actions, and to explain AR's alleged victim's reasons for delay in disclosing her allegations. I think,
So in other words, if we could just sum up on 455.
okay,
The amended statute saves whatever rationale the court applied on the sexual abuse of the victim. And it would even have permitted the admission of the conviction. The warrants were-
I think so.
And then for the physical abuse and the abuse of the victim's family, it's okay because the judge did the Gunby analysis.
Right, I think that would have been the version of 6455 type of I think that analysis remains the same.
That part of 455 didn't change except for being rearranged a bit.
Right. So,
Okay.
so I think that was proper, and that there, under the standard of review, the judge did not err in admitting that evidence. I think that was all I had, and unless there had any other questions.
That concludes your presentation on the case.
Yes.
Any more questions? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
I'll waive that, Your Honor.
Any objection to waiver of his extra time? I see none. Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.